Great, thank you. So we're going to start today by covering, and it may be a refresher for some of you who've attended our Crescendo courses, or you might already just have a lot of experience and knowledge about this, but we're going to go over copyright and trademark, like basic legal principles. And it's going to be a little dry, and I apologize for that, but you already know this because you're attending a legal workshop. So I'm going to basically present like a summary of copyright and trademark, and you all feel free to ask questions while I'm talking. And after that, I'll open it up for more questions. And then what we're going to do after I cover the content, so copyright and trademark rights, then we're going to talk about the application of that in the context of an industry standard contract. Okay, so I have a performance agreement, and we're going to talk about the importance of not just the content as it relates to the contract, but also the other provisions that you need to be aware of, and when you are entering into transactions, whether it's with a venue or with your bandmates or with the licensor or licensee. So we'll just go over some standard provisions that, I want you to be able to flag when you're looking at contracts. But most importantly, I want you to know that you shouldn't expect to be your own lawyer, and we do provide these services. So if you have specific questions that are specific to your own business or to your own content, to the extent that it is something that I can answer in this setting, I'm happy to do so. But you can also feel free to contact Jean to make an appointment, and we can go over your issues privately in a one-on-one meeting with me. So, which is probably preferable for purposes of confidentiality. So know that if you walk away confused today, you can get in touch with us, and we'll clarify it in subsequent meetings. And that's usually how things work out best. So we'll start with copyright. And the reason why we're starting with copyright is because the content that you all are all musicians, right? How many of you are songwriters? Just to know. Oh, wow. Cool. Okay. How many of you are in bands? And when I say bands, I mean beyond like your solo act. Okay. All right, cool. How many of you have LLCs? Okay. Okay, good. All right, well, then this is good. This is a good room. So we'll start with copyright because, like I said, the content that you all generate, I didn't say this yet, I apologize, is a business asset, right? Because whether you're an LLC or sole proprietorship or some other variation of a legal entity, a partnership or a corporation, whatever you're creating in the context of your career as a songwriter or a musician, that content gives rise to certain rights that you have. And that content is really important, especially when it comes to transacting, because, I was thinking about it earlier today, and I thought, one of the reasons we founded this program, this project, this organization, is because all too often in my practice, I was experiencing situations where clients would come to me after, when I say it was too late, like everything was too late, and which meant that they had signed deals that were totally enforceable, but terrible for them and near impossible, if not impossible, to get out of, where, they were, lucky to be getting paid pennies on the dollar, right? And I was thinking about that today, and I thought, for you all, when you transact around your content, especially if it's all your content, that would be akin to me transacting around my law license. And so to the extent to where if I licensed out my law license to someone for an extraordinary amount of time, and that's the only thing I have to make money with, then I'm prohibited from, earning anything, right? As a lawyer. which has happened to so many of our musicians, or often, or more often in the past, where they contracted around all of their intellectual property all at once, and it was such a bad deal that they couldn't even earn money off of their music, like, for decades. And so that basically prevents you from being a musician. So we're starting with the Debbie Downer. We're going to progress into the good news. And the good news is, again, you have access to free legal advice. And we're going to talk about how to ensure that you know what your content is, you know what your rights are, and that you know what to look for when you're transacting around them. So we'll start with copyright. And I'm still getting used to like the lean over and doing and working with this in this setting. So I apologize. I'll get into my rhythm here in a second. So I don't need this. So copyright is a bundle of rights. It's not just a right. It's 5 rights. So copyright means is the right to reproduce, the right to distribute, the right to publicly perform, the right to prepare derivative works, and the right to exhibit. So when you think about it, those 5 rights that make up that bundle of rights that copyright is comprised of, if you separate them out from each other, that's 5 different opportunities on the outset for you to transact around, you know, the distribution, the reproduction, the preparation of derivative works, exhibition, etc., the public performance right. And so you can actually segment all of those rights out from each other and license them out for different uses for different people. Not only that, but you can, depending on the type of transaction that you're entering into with those 5 different rights, that's 5 contracts right there, okay? If you're entering into, and we're going to go over all this when we get into the application, you can, if you're entering into non-exclusive deals that don't prevent you from entering into more than one deal, then, I mean, in theory, you could have infinite number of contracts, because you could, for instance, license the right to prepare derivative works, which includes sampling, to anyone who wants to sample your music, right? So all of a sudden, those contracts start adding up. And that's if you're doing business, and that's a good thing, right? Because you want to be doing business, because presumably you all want to be out in the marketplace, you know, making some money, earning revenue. And again, that's kind of the cornerstone of the material that we're presenting today, is trying to emphasize the importance of not just protecting your content and knowing what to look for, but ensuring that you have all the tools that you need to maximize your earning potential, right? And to build your leverage and to engage in best business practices, so that, you know, when you are transacting with any number of parties, you know, you're getting the most out of what you can. Okay, so back to copyright. So copyright, again, is that bundle of rights. And copyright subsists when you have an expression of a work of authorship that is original. So ideas are not copyrightable. You know, concepts aren't. Patents, there's, you know, inventions like patents. That's a separate category of intellectual property. Anything that's functional is not subject to copyright protection. But expressions, in this case, in the context of this workshop, which expressions would be your musical compositions. A lot of people refer to that as publishing in the industry, and your sound recordings or your masters. So music has 2 copyrights. We call it 2 sides. So you have a copyright in your musical composition, your song, your publishing, and you have a copyright in your sound recording, your master, okay? So for all of you songwriters, anytime anyone wants to license your music, that's 2 times the number of contracts you have. So all of a sudden, the number of contracts, you know, you're thinking about reviewing today should be doubling, right? or the opportunities to transact anyway. So the copyright, you all probably know this, but it's good for as long as you're living, or the last, in the case of 2 or more authors, the last surviving author plus 70 years. So it's, your heirs, your estate, but your heirs can continue to make money off of your work for a good 70 years after you're gone. Kids to grandkids, it's a long time, 70 years. So that's good news for you as long as you keep your rights. I'm not going to worry about getting into notice. So the works of authorship. So I said that copyright is vested, like it exists. So the bundle of rights comes into being, and you're vested with those rights. You have those rights from the moment that you have an expression of a work of authorship that is original. So it's not when you register the work. So we're gonna get into registration, and I'm gonna start rolling my eyes about registration, but you should register your works. We're gonna talk about that here in a minute. But what you need to know is that as soon as you're finished with your work, whether it's, writing your song or recording, and it doesn't, when we talk about recording, it doesn't have to be fully mixed and mastered. As soon as you have like a version of your song on a recording, then you have an expression, because you have a recording that demonstrates that demonstrates the underlying work, that shows the underlying work, the song, musical composition, right? It's able to be perceived, reproduced. And you also have the sound recording at that point, because even if you use your phone to record whatever song that you come up with in your head, that becomes an expression. And that's important, because that is when those rights exist. It's not when you register your copyrights. It's when you finish the song and you record the music. Now you can have copyright. Copyright can subsist in your musical compositions without them being recorded, but you have to know how to write sheet music. How many of you write your own sheet music? That's impressive. Very few people, like in my world, actually write their own, like transcribe their own music. So good for you all. So in that case, you don't have to record anything. You still have, as long as you have that written out, then that's something you can make a copy of. And so you have all of those rights at that point. And then the works of authorship. So that's what it means that's what it means to have an expression versus an idea. It's something that, something that you can copy, basically. That's the hard and fast rule. Yes.
And it could be as simple, right, as just a notebook paper and have the lyrics and chords on top.
Absolutely, as long as you have the chords.
Yeah.
Otherwise, it's the literary work. Right, right. Absolutely. Yeah, it doesn't have to be fancy. You could write it on a napkin and it's fine. As long as those chords, as long as the musical notes are there. So we've covered what an expression is. The works of authorship, I mean, I've already stipulated, I've already said, for today's workshop, for you all, we're talking about musical compositions and sound recordings. But works of authorship, it's a term of art that is set forth in the Copyright Act that was legislated by Congress. And this list is the works of authorship that are subject to protection. And what you all probably already know is that all of these works of art, whether it's we're talking about literary works, musical works, you all have CD covers, vinyl covers, or artwork that you're putting on your digital files, etc. That falls under visual artwork. But obviously your songs and your recordings, and you may have choreography in your music videos, and that would be subject to copyright protection. But all of those works of authorship in that list, they have a different scope of protection. So it's a little confusing, and we're not going to get into all the minutia of all that, but the distinction and application of copyright to musical compositions versus sound recordings is pretty significant. So sound recordings are kind of like the redheaded stepchild of the Copyright Act, and they have been forever. So they have a lot less protection than songs do. And that's just a result of a lot of players being in the industry fighting over, how much money they're going to spend. It goes back to like the radio industry versus the record industry, and they're always at odds. And there's a long saga that I could get into, but it basically boils down to this: the publishing industry had much better lobbyists and was much better prepared than the record industry was at the time, going back to like the 40s and 30s when all this was playing out. And so because of that, songs have greater protection than sound recordings when it comes to the performance right and some other things that we'll talk about. But otherwise, the Copyright Act applies evenly, unless there's an exception, and there just happen to be greater exceptions when it comes to the work that you all create, which I think is very unfair because you'll have enough to do without worrying about all that. But again, that's why you have your free lawyer. Okay, so these are just some examples of, you all already know what the expressions are. I forgot about film. So of course, your choreography in your music video would be protected. But of course, if you have a stage play for the people who are performing it, then that would be a work of the performance arts. And if you took the video of it, that is an audiovisual work. So you could actually, with your music project, have a copyright in just about every single class of those works of authorship, with the exception of an architectural work. I'm sure someone's done it. I bet if we asked ChatGPT, they could do it, but I'm not going to try to do that right now. Yes.
Can I ask you something real quick?
Sure.
What about photos? Like, how does that play into, and specifically, even a little more complicated question maybe, but like, you create a piece of artwork, and then about the photo of the artwork.
You mean you've used the photograph to
Right,
make
for marketing materials.
okay. For like sculptures?
Is that like, yeah. for
Okay.
instance,
Okay.
Is that,
That's
Are
all
photos
subject to
being
copyright
protected?
protection. Yes, if photographs would be protected as works of as visual artworks. Absolutely. And there's different rules that apply to photographs, but you do have copyright in the photos. So, I mean, if you have photos in your liner notes or photo on your album cover or on your single cover, then that's subject to protection as well. All of it. I've actually never thought about the idea of having all of the works of authorship protected in one music project. I don't know why that aha moment just happened, but thank you all for that. I'm gonna say I'm a little bit smarter today because of this workshop. Okay. So with ideas, and this is kind of important. So with ideas, sorry, I got something in my throat. Because you all start every project with an idea. I mean, they don't just come out of the blue. Like your songs and sound recordings, you may think they do, and maybe they do. We could go there. We could get into all that, but that's not really what I do. So I'm just going to assume that, your brains work like everyone else's, and that the people who are neurologists, we'll just defer to them. And that, whether or not you realize it, whether or not it's subconscious, you've been thinking about something before you just take it and put it on paper or record it. So if you spend, more than a second or two, if you are investing time into actually creating your songs, and let's say you're collaborating with, a few people, or, you're working on something and you're shopping around with some of your other songwriter friends. And certainly, if you're recording music with other folks, and if you're recording music, the difference between recording music with your phone or in your closet or in your home by yourself versus, in a recording studio, you have exposure, right? It often is the case where during your production process, because there's pre-production, production, and post-production, right? So the ideas start germinating, you start to produce them, and then you go to edit them or mix and masters, as in the case of a record. That often involves exposing your work, your content to other parties. before it's finished. Because you don't have copyright protection until it's finished. You have to be able to protect yourself. So you can do that. While ideas are not copyrightable, you can contract around ideas. And I realize that like NDAs are a really unpopular thing to talk about these days. But that's, for instance, one way you can protect yourself if you're worried about a third party getting a hold of your content, while it's in production before it's finished. There are other ways to do that as well. And we just don't call them NDAs, but they basically read kind of like them, right? If I'm inviting you to come in and work on my project, or to listen to my music, or to contribute to it in any way, shape, or form, then I will do that, and you will have access to that contingent upon you're accepting that I am not giving this music to you. Like, this music is mine, and you're not allowed to use it in any way, shape, or form. So if that's what the contract would look like, and I could, I actually have contracts that read not too differently from that. That are just a couple of lines. And what a lot of people don't realize is that you don't have to have contracts that, fancy contracts with lots of legalese that, that you print out and sign and notarize and all that. Okay. It's ideal to have a formal agreement that memorializes the arrangement that you have with another party. But the plain fact of the matter is that verbal contracts are enforceable. And if you have evidence of a verbal agreement, or if you're emailing back and forth, these days, people are entering into contracts all the time without even knowing it. Because as long as there's some sort of consideration, like let's just say you're paying someone to mix your record, you don't have an agreement, but you have emails back and forth after you've paid the person to mix your record. That's all subject to all of the provisions that you've stipulated when you're going back and forth. So most of the cases, so I teach this at Tulane and at but I really get into contracts pretty heavily at the law school. And it always amazes my students because, they're taught, basically, this is a contract and this is how it's enforced. And, these are the hard and fast rules. But most of the cases we go over coming out of the music industry over decades, in the cases that are litigated, where the courts have to determine the nature and scope of a contract and how to enforce it, the judges look at the plain language of the agreement, but almost never enforce the entire plain language of any agreement. And often is the case, especially in the film industry, where there's so much going on and there's so many contracts and they're not reconcilable, that they just kind of give up on that, right? What they really look at is they look at the intent of the party. So they look at all the circumstances. They look at the party's conduct. So all of your emails, all your texts, right? They look at any performance that is rendered. So when I say performance, well, say if you booked a gig and performed it, then you've performed your obligation, right? If you're a concert promoter and I nearly said flyers. I'm old, okay? So I'm picturing, going out with a staple gun and flyering up, Brett Street, right? But if you're a concert promoter and you're promoting a band online, or if you are a venue and you book a band and you promote the band online, that's evidence of what we call performance, right? So if there's any partial performance, the courts look at that. But the biggest thing they look at is the reasonable expectations of the parties. So, and that's just common sense. Like, what did you all expect when you entered into this arrangement? What was reasonable here? And that's all evidenced by all the circumstances. It's a good reason not to go to court, because that's the reason why sometimes people go into court thinking they're going to win because they have this ironclad contract and it doesn't work out. And I spend a whole semester every spring going over cases where that exact outcome happens, where it is like, oh my God, I spent a million jillion dollars to be right. And I was totally right going into this. And the judge didn't word for me, because they didn't, they looked at all those circumstances and decided that they didn't want to enforce the agreement. So there's a couple lessons from that. Be wary of what you put in writing, okay? I'm not trying to make you all paranoid, but I often think about it. I'm like, what did I just sign up for? So be wary of that. Just be aware of that. Maybe I should not say wary, but be aware of that. And, know that if you get cross-eyed with, your bandmates or, with a collaborator or with a label or what have you, even if your contract seems like, you're the right person, you want to make sure that you can try to work that out before going into court, okay? Because you just never know, because you can't remove the human condition from a court of law, right? All these people are human. Most of these judges don't ever see cases in the entertainment sector, even in Los Angeles, they're exposed to more immigration than they are to entertainment industry contracts. So just be aware of that and know that it is important to have your agreement, because if you don't have an agreement of some sort, then what that does is it sets you up a situation where, and I mean, this is common sense. I know you all know this already, but it sets you up for a situation where, if you feel like whoever you contracted with or whoever you have an understanding with doesn't understand what they're supposed to do, and maybe they just don't want to do what they said they were going to do, which happens all the time. I mean, how many times have I done that? Not often. I like to try to live up to my word, but we've all been in situations where we decide we don't want to do that anymore, right? And we certainly know people who do that, So if that situation arises and you don't have any evidence, then that is really hard to navigate. And it's really hard for your attorney like me to navigate. But so contracts are, can work really well as deterring mechanisms also, because it looks like you're serious and you got a piece of paper and it looks legit and really formal. So it tends to be the case where, at least in my experience, people who, have written agreements, where they're less likely to be in a situation where they're inherently vulnerable to a breach, breach of duties, that sort of thing. We're going to go into some other contractual considerations when we actually pull the contract up, but these are things I wanted to get into. Some of the legal principles that I wanted to get into, and realities, okay, the real life realities, as we're going through the copyright and trademark section of the workshop, because I just want you to be thinking in the back of your head, while it is important to protect and enforce these rights, and while you do have these rights, before they become confected, there are ways to protect yourself in the pre-production and production process. And also, once you do have copyright, once you do have a trademark once you are using a trademark, okay, so it's important to have, it's just really important to be clear about how you're transacting with your rights, because clarity's I think is more important than a scary contract. A clear contract is. Yes.
So to that point, just the mere process of sitting down with the other party and creating is a tool for you and that other person to get on the same page.
Exactly. Bingo.
Because if y'all sit down and you write this and say, so that means, and you're like, no, because we all think one thing.
Right.
And we think the other person thinks the same thing, but often they don't. So just sitting down with the other person and a piece of notebook paper and going through, say, number one, number two, you can get on the same page or split before y'all get married.
That is what I was going to get into when we got to the contract section, and I'll reiterate it, but that was very well said. And that is the most important thing to do when it comes to memorializing your relationship. When I say relationship, I mean, your contractual relationship, but same thing with marriage, right? Yeah, because, you want these agreements to do just that. They want the agreement, a formal agreement, a written agreement should reflect the arrangement that you have that works. Okay. You shouldn't, so if you have an agreement with someone where you're licensing your music for 5 years, that's what your agreement should state. Okay. But too often I'll have a client that comes to me. Their understanding was that, they were licensing their music to someone for 5 years. But the person who gave them the contract just gave them whatever was on the shelf, or purposely wrote up something that was completely different. And all of a sudden they're in an exclusive license, on a non-exclusive license, for 12 years, where they don't get any revenue, right? And that happens with people who are in bad faith on the other side, who, there's, you all know all the horror stories, but more what happens is, when people, don't want to pay their lawyer, or don't talk to their lawyer, or they don't talk to each other in the process, they end up with an agreement that doesn't look anything like their arrangement. And that happens all the time. And it's so frustrating. So I think that what you just outlined very clearly is the most important part, because you get to know each other during the process. You will understand what it is that you expect of each other. And then you can just write it down, right? If you don't go through that process, which a lot of people don't, especially people who, frankly, there's some luxury to being able to access free legal advice, because I go through this process with all of my clients, when that is what I'm tasked with doing. But, people who hire lawyers, who have 2 different lawyers, and this is just the nature of the legal industry, and it's why we have a bad rep, okay? What happens all too often is, I talk to my lawyer and I tell them what we said we were going to do, and she talks to her lawyer, and our lawyers come up with 2 completely different contracts. And by the time they duke it out and bill for their hours, we have an agreement that we can't afford to pay for any longer for it to go on. And we just take what we have and run with it. And neither of us know what's in that contract at that point. And it's going to cost us to go back to our lawyers to figure out what it is. And that's when, that happens all the time too. So just be thankful you have access to us. I'm not trying. I didn't come here to put a feather in my cap, but you set me up. You teed me up for that. So, all right, going into, let's see, where am I? I always talk longer than I'm supposed to. So, we talked about the expressions. We talked being fixed, being able to be copied. We talked about the laundry list of, not the very short laundry list of works of authorship. And then, your work is going to be original. Your work is going to inherently be original. The standard for originality is a minimal amount of creativity. Okay. So by the time you create a song, as long as you're not stealing from someone, it's going to be original. This is, this is something that I get into more in depth with visual artists and photographers, because especially like jewelry artists, but some sculptors too, because anything that is, when you think about it, like geometric shapes are the building blocks for art, right? So anything that's just a geometric shape, unless it's a sphere in a sculpture garden, and all of a sudden that's fine. But anything else would not be copyrightable, because it would prevent anyone from not prevent anyone from creating art, but using it legally, right? So the same with songs, the same with recordings, like a common 3-note sequence is not going to be anything that's a building block of a song, of a composition, like your standard blues riff, that sort of thing. Any common chords, common sequences are not going to be subject to protection. So as long as you have, more than that, then your song, your compositions are going to be copyrightable. And the interesting thing about recordings is that almost all recordings are inherently copyrightable. So while, but I don't know what note it is that James Brown screams all the time, or he screams different notes, but you can have one note that James Brown is singing. And while that one note wouldn't be copyrightable as a composition, as a recording, it would be, because only he can sound like that, right? So it gets a little nuanced around all that. And I'm not going to get into all that today, because I think your eyes might start swirling and that, and we'd never get to the contract. So, but there is some distinctions there too. With derivative work, so I want to touch on this because a derivative work, I've recently, was recently in a transaction, dealing with a transaction where it occurred to me I need to be a little clearer about sampling. Because we talk about, what do y'all think of when I say sampling? What does that mean?
Taking a recording and working it into your new work.
Right. Yeah, that's what most people think. And it's what I always thought before I became a copyright professor. I mean, it does mean that, like, a derivative work is a work based on another work, whether it's in the public domain or whether it's a work based on a work with existing protection. And from sampling, you all know that you have to get permission from the author if you're going to use someone else's recording, right? Otherwise, you get slapped with all kinds of legal fees and penalties, and have to take your work down, and it's just a nightmare. Yes.
Does that include interpolated works?
Yes, it can. Depends, but yes. We're just going to say for today's discussion, yes, but there are exceptions. I could teach a class on that alone. So thank you for asking that.
Would you ever play like two different songs side by side and have this whole?
Oh, have I? I've done it, but not with expertise. I've listened to two songs side by side and gone, well, they sound a lot like the same to me, but I'm a lawyer, not a musicologist. And what I have learned is that two songs can sound exactly the same and be completely different, and two songs that sound completely different can be exactly the same. And I am not the person to go to for that. It's when you start, but by the time you're asking me that question, that means you're in court and you're paying experts. So if someone's making money and it's not you. But so for sampling, so yeah, so if you use someone's, recording in your recording, that's traditional sampling. That's what we think of, right? That's a derivative work. You are creating a derivative work, because even if you're just sampling a little bit of content, your work still includes someone else's work. It doesn't mean, a derivative work doesn't mean that the work that you add to it is that much more, right? There's a lot of mythology around how much you can use of someone's work and how much work you have to add for it to be authorized or derivative or what have you. But what you need to know is that if you are using someone's work at all, as long as the part you're using is original, then you need to clear it, and it's a derivative work. You need to get permission, because that's sampling. But what I think of sampling, which is also sampling, what I'm about to tell you, extends beyond using someone's recording. So if, for instance, you are writing a song and you're doing a cover, but you add a verse, that's a derivative work. So you can no longer just get a cover license, right? Even if it's as long as the verse that you're using is minimally creative, which means more than a phrase, then you have to get permission, because you're still sampling. You're still sampling someone's song. It's not the sampling that you think of in the traditional sense, or in the more commonly used sense. But if you add on to anyone else's work, whether it's a song or well, more than likely in this context would be a song, then that becomes a derivative work, when it comes to licensing. And so you can't just get like the really cheap mechanical license to do a cover. It's no longer a cover, because you all know that covers, if you if you cover someone's music, you can just clear it through, whether it's song file, used to be Harry Fox, or, through the publishers, right? A lot of the major publishers have just as easy clearinghouse sections of their licensing department as song file, formerly Harry Fox did, because they got their shit together finally. But you have to actually get a hold of someone and get permission. They have to get a hold of the songwriter or the songwriter's estate if you're going to add anything to a song. So just be wary of that. And I call that sampling too, because it's a different form of it. And it's something that, I think when most people think of sampling, it's, using someone's recording, but it extends beyond that. And that's why I wanted to clarify that in the context of, what a derivative work means. Yes.
You're on stage.
And I'll get to you. Sorry. Yes.
You're on,
You may be asking.
if you're on stage at a venue with a license and you're covering a song,
Mm-hmm.
and then you do your own verse for fun, is that technically covered by the license that the venue is paying for?
Should be, and you're lucky because you're not recording it. So because it's a public performance, then you're fine. As long as but it's the venue's obligation to have the performance licenses. And you all know that not everyone does, but that's not on you. That's on them. But if you had recorded it and done something with it, used it, distributed it, put it up on iTunes, then that'd be a problem. And you would be lucky if the person, because there's all the software that allows people to find their stuff, find their content. So, if it's owned by an entity that has the resources to do that, then more than likely they'd find you, and you'd be lucky if they just asked you to take it down. Because most of the time they come after you for as much money as they can get.
Does that count if you're just screwing up the words to the song?
Well, it depends on what just screwing up the words of the song means. I mean, if it's,
Forgetting lyrics, making up your own.
well, it depends. That's one of those case by case analyses that I would suggest, you talk to me outside of this, and love of God, don't set yourself up for liability publicly. Okay, so I'm going to breeze through some of the rest of this because I really want to get into the contract stuff, but work for hire. So, the difference between an author and a claimant, the author is the claimant. You as a songwriter, you as a recording, as a musician who's recording their work, are the author and the claimant, unless you transfer your rights to someone else, unless you assign your rights to someone else. And then that person becomes a claimant. And that's why you hear about, like all the Beatles stuff, making their way from ABCO to, the Universal to BMG to Michael Jackson and all the many parties that, before Paul McCartney required some of those works, because it's like having a title to a house, right? Like how many owners there? I think that there have been like something like 100 owners of my house because it's 200 years old. And, yellow fever, people died a lot. So, I mean, it just did. And so, then there's a period of time where the house transferred a lot, right? Because everybody got wiped out. But sorry, I do that every time. But, it's just the way it is. And so, that meant that the title transferred each time. And so, once you give up your interest to the work, anybody can, I mean, you hear about these labels and publishers merging and getting sold off. And I mean, now there's, just 3 major labels, but they have like all of the other, labels that I used to think were major labels because they all own each other, right? And so, every time that happens, there's a transaction with the music that is part of the catalog, like an imprint's catalog, So you can have a lot of different transactions in a copyright, but as long as you don't assign your interest to anyone, then you maintain your copyright, unless you sign a work for hire agreement. And I'll get to you. A work for hire agreement is where someone specifically commissions someone else to create a work. So if you are getting in the studio and you need, people to lay your horns, or you know, percussion, do stuff that you don't do, you know, with the various instrumentation, and you want to hire a bunch of musicians that aren't part of your regular band to, you know, make your recording sound better. We call them session artists. Then you better get them to sign a work for hire, because if you don't, then they co-own your sound recording with you. They're co-authors because they contributed to the sound recording, assuming that they contributed a copyrightable amount, right? That's a good reason to come see me to get work for hire agreements, you know. The other way that you can be divested of your rights before you even before you even start creating, I nearly did the Arkansan way. This is your fault. Just talking to you for a minute has done that to me already. Without the bourbon required, usually. The other way is when you are creating content in the scope of your employment. So if you were, you know, employed by a publishing company, a song publishing company, or by a record label, if you're creating, you know, songs or records in the scope of your employment, then that's a work for hire situation. You're actually never the author then. But, you know, here for this room right now, the most common situation, you know, where work for hire would arise would be when you're collaborating, okay? And just know that, you know, if that happens, you need to work out those details in advance. And if you don't, then everyone's a co-author, right? And then you all everyone has the right to do with the work what they want to do, as long as they don't prevent each other from contracting around it. So if you're collaborating with someone and you know, you co-own the rights, then you all can do what you want with that. You can enter into non-exclusive arrangements as long as you account to each other, right? Because you can't sue each other for infringement because you're both co-authors. Now, if you get in a situation where, you know, one of your collaborators, you know, goes to Sony, which you probably like, maybe not, and gets into an exclusive deal and doesn't tell you about it, well, then you have recourse against that collaborator because they cut you out from doing anything with your work. But that's a contractual recourse, or if they breach their fiduciary duty, it's not a copyright claim. So I'm not going to get too much further into that, but you should just know that. The performance rights organizations, for all of you songwriters in here, just know that you need to be registered with BMI or ASCAP or CSAC, as CSAC's invitation only, I believe still. And they collect the broadcast royalties from your songs being performed. Similarly, Sound Exchange collects from the pool of resources that are connected to, or that are required to pay for broadcast licenses for sound recordings. I'm hoping that at some point, and it seems like it will happen, that sound recordings will be afforded the same protection as songs with respect to public performance rights. Right now, songs just get more because, and this goes back to what I was saying at the beginning of this monologue, that, you know, the way it worked decades ago, the publishers just, they lobbied for greater rights. And a lot of that had to do with the context and the time. And, you know, things were different. And one thing I think that we all know in this room is it takes, well, unless you're Donald Trump, it takes a long time to get legislation from point A to point B, generally speaking, because that implies that, you know, it takes a lot of people getting along and figuring out, you know, what a bill is going to look like, right? Which means a lot of, you know, a lot of lobbying, a lot of duking it out, and a lot of BS, right? So it's been a long time since sound recordings have been equal to musical compositions, but they've made some, there's been some progress, including the Music Modernization Act, which was enacted in 2008. It was, well, 2018, I apologize. I always say with it, I mean, we want to like the Music Modernization Act, but I'm like, it was proposed by Senator Orrin Hatch, you know, signed by Donald Trump and endorsed by Kid Rock. What could possibly go wrong? It looks like an improvement, and I hope it turns out to be an improvement. It does extend some of the protection that would otherwise be disparate to sound recordings and to producers of sound recordings. But it's got some flaws, and it's because it's still in beta mode, basically. You know, this thing, so 2018, I think into 2018, it got put into action, or it was approved. And I mean, you all know about the pandemic, it happened. And, you know, they were trying to figure out what this act, you know, how it would be implemented around all that time. And so there is an agency, it's called the Mechanical Licensing Collective. And for you songwriters, you need to register with the Mechanical Licensing Collective because it's going to be like the new BMI ASCAP. It's not the same. But I say that because it's kind of fun, because as part of this act, it requires BMI. If you all notice that Harry Fox, like Songfile, there's something going on with Songfile when you go to their website, and you know, when you access your BMI and ASCAP accounts, when you search the repertoire, they're all connected. And that's because this act requires essentially greater transparency for the performance rights agencies, because they've been a little crooked for a long time, right? And so they are basically reconciling their databases. And they're doing that with the Mechanical Licensing Collective, which serves to collect all of your mechanicals, all of your songwriting royalties from the streaming platforms. Basically, I mean, the streaming platforms like Spotify weren't paying. And so instead of someone suing to make them pay, we, the taxpayers, are paying for another agency to make them do it. So, and that's okay. It's what worked, right? We'll see. I hope it works. It purports to be working right now. I haven't met anyone that's gotten a check from them yet, but they've only been up and running for a very short amount of time. So that doesn't really mean anything. They were still in beta mode on their website like 4 months ago. So register with the MLC. It's super easy. I do it for clients all the time. It's BMI registration is really easy, and somehow it's easier than that. So do it. Otherwise, you're like missing out on that revenue. Okay, what time is it? 3? Yes, ma'am.
I have always found performing rights organizations to be really confusing.
Yes, they were on purpose, and they are still on purpose.
There's BMI, ASCAP, CSAC, but there are also like several other ones that have popped up over the last couple of years. As a musician, do you register with one of them, or do you register with multiple?
That's a good question, and thank you for asking that.
Because venues pay, well, they're supposed to pay all of them.
They're supposed to have blanket licenses with all 3 agencies, and most of them don't, but some of them do. If you're a musician, you can only register with one of them. Generally speaking, the terms of their contractors, and we're going to get into the terms, are for 2 years, and after 2 years, you can give them notice and switch to the other. But I have not ever experienced one being BMI or ASCAP being better than the other, except that for me personally, professionally, I have contacts at BMI. So I like to work with BMI because I can make them do their job. I don't know anyone at ASCAP anymore, but that's not a good reason to, I mean, unless you're working with me, you know. And then that's a good reason to register with BMI, if you ask my clients. But yeah, so if you're a musician, you can only be registered with one. If you are a publisher, which means that you're collecting someone else's work, then you should be registered with all 3. And it's complicated. We can talk about that, you know, outside of this. Otherwise, again, everyone's going to have the swirly eyes. So, okay, let's talk about any more questions about the PROs. I know I glossed over that, but I'm looking at the time, and I'm really trying hard to focus in on the content that I have that is most relevant to the next exercise, which is the contractual one. So I just blew through that. Does anyone have any questions? And we can talk about it outside of this too. I mean, you all should all be registered with the performance rights organizations. That's really important to do. And I can help you do it and tell you how to do it and why you need to do it. And just the biggest thing is just remembering your password, honestly. It really is. Like that's more than half the battle, because they'll lock you out. BMI does that. After 2 times, they'll lock you out, and then it takes like a fucking week. Whoops, sorry, I'm being recorded, but it does. Okay, so let's talk about copyright registration. So yeah, copyright registration is important to do if you can afford to do it. And I shouldn't say that. Okay, so it's registering your works, your songs and your recordings with the Library of Congress is certainly best practices. Okay, and it extends the scope of protection insofar as, like I said, once you have a work that is an expression of a work of authorship that is original, you have that bundle of rights. What registration does is it gives you the opportunity to go after someone who has infringed on your work without making any money and pursue statutory damages, which hardly anyone ever does. As long as you catch them within a certain amount of time and you can afford a lawyer just to mess up someone's life, okay? Statutory damages are, a good reason to register if you're registering, if your content that you're registering is something that you can do on the cheap. If the other thing that registering gives you is the right to sue in federal court. And that's kind of a new thing. That's probably going to change, but you can still sue in state court. And guess what? Most people don't file a lawsuit. Most people settle out of court anyway, so it does do that. As an attorney, I have to tell you that it is best to register your works because I've always said that until recent years, and it's true. It's best practices to do that. It used to be the best insurance policy you could buy, right? Even though most people didn't, go to court. It was smart to do. And it's not that that has changed, but the Copyright Office has not surprisingly, has not adapted the registration protocol to reflect the reality of an everyday musician's life and their the way that they go about the frameworks for protecting content. It doesn't reflect the reality of a musician's needs for protecting their work. Because if you are releasing a single, once a week, or, every time you release a single, if you're not releasing an album at the same time, like all of your work at the same time, because you have to register all of your works according to a unique combination of authorships. So, all the authors have to be the same on one application. I'll get to you. And because if you published your work, if you put it out online, it has to be the same date. You can't fake out the Copyright Office because they look this stuff up now. So if you release, a single on November 12th and release another single on November 17th, that's two different forms. If you release an album at the same time, that's fine. And you can register up to 10 unpublished works from the same year. But if you're looking at, publishing, your singles, like putting them out for digital distribution, which is what a lot of my clients do. They drop one song one week and one the next, or 1 month, or however, then that becomes really expensive. And so then you have to just run a cost benefit analysis, because that's $65 or at least each time. And so what I'm here to tell you is that as an attorney, you should probably register your works. As an advocate, I'll help you figure out how best to protect your content, because you might be able, if you're looking, if that's your framework for releasing your music, to do it sporadically, then you might want to save all that money instead of paying Uncle Sam and put it towards, promoting your work, right? So people actually buy it because they know it's there. So we'll talk about that. And this is probably something I shouldn't say on the Zoom camera, but I don't care. I mean, I'm really, 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 I feel strongly about this. So, and I hope that the Copyright Office changes their protocol, but like I said earlier, it takes the government a long time to do things sometimes. So, except for Julia, she's like the fastest person ever. Oh, you had a question.
Would it be cheaper to register one album?
Yeah, if you have an album, for sure. And if you have an album and you're dropping a whole album, then that's the thing to do. And that's cheap, and you should definitely register your work.
So in theory, could I release a bunch of singles and then later on put all that into an album and then register one album to copyright all that?
No, not if you want to, not if you're looking to seek the kind of protection that you want out of a copyright registration. because it will only protect the compilation and not the underlying work. It will only basically protect the order that they're in. It's the new way.
The order that they were in.
So if the Copyright Office can go on iTunes or Spotify and see that those songs were released on different dates when they were first published, then they will not allow you to register them as a compilation of published works without compromising how the registration extends. So it wouldn't extend to each individual song. It would extend to the entire thing. And not with the songs all broken up.
What if?
If
the
that makes
majority-
sense.
What if the majority of the album are unreleased songs?
Well, if they're unreleased, then you don't have to worry about it. You can release up to 10, like I said, unreleased, unpublished songs.
What if the album has a share of both?
Well, then you're looking at two copyright applications already. You can no longer file a registration application for published and unpublished works at the same time, which you could never do.
Because some of the songs already exist.
Yeah.
In a certain form, so you can't.
You have to, yeah,
They
so you have to
already-
designate whether they're published or unpublished, and there's specific forms for that. We can get into this in greater detail, because we
Okay.
can talk about that for a long time, and I got a breeze. And I'm happy, like, when we have time left, I'll go over the stuff that people want to get into more deeply. Oh, hell. Damn it. Okay, sorry, I gotta do this. I gotta figure out where my mouse is. Okay. I can't see it on my screen, it's too small. Okay, we're not gonna get into fair use. I think that we should probably get into trademark now. We've gone over the basic principles I'd like to discuss for purposes of getting into this contract here in a minute. So while a copyright is a bundle of rights that extends to works of authorship or work of art, songs and recordings, a trademark is a right to a source identifier, right? Trademark is a brand. And while copyright lasts for your life plus 70 years, trademark lasts forever as long as you're using it. I mean, you have to be a legal entity because you're not going to live forever, but I mean, I don't know, with all this AI stuff, maybe we're going to live forever now. Who knows? I don't want to live forever. So assuming we don't live forever, a trademark would last as long as you're using it, or as long as whoever you're working with, or in the case of a legal entity, as long as it's being used. So this is one of the reasons why, Disney's able to protect Mickey Mouse and Yoda and all of the other content it's acquired or started out with, and acquired over the course of time. Because while their copyrights are going into the public domain, because every year that passes is another year that content that was created when there was existing protection goes into public domain. And in a few years, Disney's going to start really sweating, because that's when some of their most lucrative cartoons or animated figures are going to be up for grabs. And so what it's doing is it's using, I'm not saying that it's doing this just to get around copyright expiration, but it is convenient. Disney's well known to exploit its content for merchandise. This is why you can find Yodas on jammies, and Mickey Mouse on luggage, and chains and bath wash, Cinderella bath wash. You can find snow globes, anything, any kind of tchotchke you can think of. You can find a Disney character on it, or Star Wars character, and that means that they're using that as a trademark, right? Sometimes it can be subject to copyright protection and trademark at the same time, but your trademarks can be like your band name, okay? So, or your artist's name. Now you don't have rights to your legal name unless it's like, so Beyonce is such a household name that name is acquired secondary meaning on its own, Beyonce, right? But the general rule is that you can't prevent someone else from from using your legal name. Otherwise, no one can be named your legal name. But if you have a pseudonym, you know, that you use when you're touring, or that you're using to sell records, or your band name, there's all kinds of great band names, then that's a trademark. And it's yours, and it's only yours as long as you are the first to use it in the context of the entertainment industry. The wonderful thing about the internet is that, you know, besides like the democratization of access, you know, it's, you know, Google's search engine is so much better than the trademark office's ever was, right? So it's easy to find out whether or not someone is out there, potentially out there, using a name that you want to use. But it's also really easy for someone who wants to come after you if you're using a name that they were using first to find you. And so you want to make sure that whatever you're using as your band name or your brand or your label or whatever music business you're running wasn't being used by someone else first, because the trademark rules are that the first person to use it and a certain class of goods or services can continue to use it as long as they're using it, with exception. Yes.
So when you say pseudonym, that means anything besides your first and last name?
Well, it just means however you're performing as an artist.
Well,
Performing as.
So I'm asking that because my full name is Randy Martono Chai, and I
Mhm.
expect that's really long.
Thank you
So
for
I
the
cut it
example,
down
yes.
to Randy MC.
Okay, that's
So
your band, that's your
my
artist name.
Would that be considered a
I think those are two
pseudonym?
different. Randy MC would probably, yeah. Yeah, that would be your pseudonym. Because that's not your name. That's what you're performing as. And so generally speaking, that could be subject to protection. There's some nuances there, but we're doing general, okay? And again, as long as you're using it, as long as you continue to use it, which means, and using it in interstate commerce, failed to mention that, but the plain fact of the matter is that you all are not transacting outside of, I mean, you might be transacting beyond the internet, but everyone here is transacting on the internet. Maybe I'm wrong about that. And if so, I'd love to know what you're doing. But anymore, you know, most people are online. And if you're online, you're part of the global marketplace, and therefore you are using your trademark in interstate commerce. Back in the day, back in the dark ages, when I started practicing, before people were doing anything online, because it took 5 years for dial-up to work, you know, we would have, I would instruct my clients to, you know, send a CD to their friend in Mississippi with an invoice, and we used that to send to the trademark office to show interstate commerce. But that's crazy. No one does that now. You don't need to do that. There's nowhere to buy the CD, you know. Now everything is online, almost everything. So as long as you're doing business online, then that shows proof of use in interstate commerce. With registration for trademark, and look, the reason why I'm about to conclude with trademark is because trademarks are like, the rules for trademarks are hard and fast. Like it's just, you know, it's the act, the Lanham Act that's the legislation, the federal legislation around trademarks is super clear cut. It's like the exact opposite of the Copyright Act in that regard. It's not complicated. You know, we're talking about one bit of content, you know, not, you know, a bundle of rights that can all be transacted interdependently, right? And the flowery language in the Copyright Act, and the fact that, you know, all the works of art are treated differently. With a trademark, are you using a brand? If you're using a brand and you're the first to use it and you're not infringing on someone else's mark, then you can keep using it. And the registration rules are similar to Copyright Act. If you can afford to do it, okay. But anymore, like, it doesn't, like, the internet is so much, the search engines are so much more effective than anything in the trademark office. So yes, with registration, you do have a right to pursue an action in federal court for infringement. And, you're the presumptive owner, which doesn't really mean that much, but it meant something to the legislators at the time when they enacted it. And it certainly meant a lot to the attorneys that were billing to register these things. And, you get a shiny certificate, but as long as you're using your trademark, I mean, there's a digital timestamp on your use, right? Like, it's hard to hide in the context of the online marketplace. I mean, it's easy to show who the first person was to use a mark as long as both people used it on the internet the first time, right? And for the vast majority of scenarios, that's going to be the case. So do you need to register your trademark? Talk to me about it outside of this and we can weigh the costs and the benefits, but you still have exclusivity regardless, as long as no one else does. And that's the thing that you want to worry about. And the other sort of hazard with trademarks is in the context of the online marketplace is that it's really hard to find marks that haven't already been taken, even if someone's not really doing anything with them. Because as long as it's up somewhere, then, and there's like a scintilla of use in commerce, which means, someone updated their Facebook like last year, then they still have the right to it. So I have clients come to me all the time wanting different trademarks and they're taken, so you got to get really creative, but there's some really creative band names out there. And we can get into the nuances of trademark if you want to talk to me about it. Just know that, again, I mean, some of it's common sense. There's 44 different international classes of goods and services. Entertainment is one of them. I'm not going to go into all those classes as long as it doesn't seem like your use of your brand is interfering or likely to confuse a consumer that is considering purchasing another type of good with a similar mark. As long as you're obviously offering different kinds of services or goods, then generally speaking, with exception, you should be fine. Okay, I'm not going to get into any of that. Oh, good, that part's over. Are there questions? Yes, and let me look at the time real quick. Okay, cool, we're good. Yes.
So do you think there's a word of caution there for people, like especially with the trademarks or when you're putting your music out or doing stuff on social media? If you go out there with this new name, then there's always a risk that somebody else may pop up and say,
Yeah.
hey, you're using their name. But if you've already built like a following there, and your account gets wiped out, because somebody else is.
Well, that's a good question, and that happens, and that happens, but that's why it's so important for you to do your research before you start using a name, because if you don't and someone else has that name, then what you just described can happen, and it's happened, with some of my clients numerous times. I'm going to get the screen share to work first, and then I'm going to get to your question. So yes, that can happen, but do your research ahead of time, and that'll mitigate the chance of that happening.
Actually, for the people on Zoom, when you get a question to the audience, can you summarize it real quick before you answer? Because they can hear you, but they can't always hear the audience.
Okay, yeah, sure. Hold on just a second. Let me come back in here.
And that's just another.
Okay.
Don't stress.
I also can't see the stuff I can't see the chat, so.
No.
Okay,
I'm monitoring that.
thank you. Okay. And I'm going to get right back to your questions. When I said I can't see my mouse, I can't see my mouse right there. Okay, I need to go in here. Maximize this though. It kind of hurts. Okay, what other questions?
Would it make more sense to copyright first and then publish,
No.
or vice versa?
No. I mean, it's really whatever works best for you. There's a rule that if you really want those statutory damages, you got to register your copyrights within 3 months of publication. But, otherwise it's 6 one way, half a dozen the other.
So what happens if 3 months pass, you can't?
Well, you got to register your copyrights. If you're concerned about doing it, you have 3 months if you're concerned about being able to pursue statutory damages. Otherwise, it's, you've got time. And I mean, I've registered copyrights, back when I used to litigate a lot, I would register a copyright and all you need is a serial number. So you get that online, in 10 minutes, and I'd put it in my complaint, go down to federal court. Don't even have to have a registration number, and that's fine. And it could be for a work that was created, 15 years ago. I don't think I ever litigated over a copyright that was registered timely. But I never pursued statutory damages either.
I am along the same line. Are you saying that you should register each work first as an unpublished work and then as a published work once that so say like single is released or song is released?
No, so if you register a work as an unpublished work, you can't, unless you've changed it, like unless you've rearranged it and becomes a derivative work, then there's no reason to register it again.
Would that be somewhat the route around this single drop?
As
method?
long as you have, yes, and you can do up to 10 as long as they're from the same year,
Okay.
same year of creation. Mhm.
Thank you.
And have all the same authors. Now, I don't know how the Copyright Office figures that out. I think you just like swear under oath, but they do actually, like if you, and I'm not saying to lie, you are swearing under oath. So you make sure that all your songs are created in the same year for all your unpublished works, and that helps protect you too, because if someone else, steals your work and says that they created it, the year before and happen to have a registration, which you can't find. But yeah, just do it the right way. Yes,
Is it true that the poor man's copyright has no legal weight in court?
that is absolutely true. And I will restate that. A poor man's copyright has no legal weight in court.
What about if you're posting to social media that has timestamps or whatever,
It helps for showing, it doesn't, you don't have a registration. It doesn't mean it's registered.
right?
But as far as like,
Establishing proof of creation or whatever.
yeah, I mean, it helps in your legal argument, but not as a registration. It's part of the narrative, right? But what you all need to know, I mean, and I love that you're asking these registration questions, but again, you have recourse from the time your work is finished. So, I mean, how many cease and desist letters do I send out a month?
Yeah, decent. And yeah, very little of this actually, as Ashley was saying, ends up actually litigated.
Well, and how often am I able to resolve my seat? Like usually with exception, if I send out a letter of demand to someone who's infringing upon one of my artist's works, it works.
Right.
Like almost every time.
People know it.
Yeah. And, regardless of, the power of the other side. I mean, I went after Netflix recently over a work that was used in one of their big budget films that did not have a registration. Wrote a check. I mean, it's pretty clear cut. Yes.
I ran a recording studio that had my name on it for like 10 years.
Mm-hmm.
And then I got a cease and desist.
Oh, no.
From a lawyer in Texas that said I couldn't use that name.
It's always the lawyers in Texas. I bet they were from Podunk, Texas too. I've had the same problems. Go ahead, tell us the rest.
Said I paid for registering the name of his recording studio he just opened. And I've been in business for over 10 years and I just never registered my name because I was just a little fish in a little pond.
You didn't give it up, did you?
I called him and I said, dude, I'm a little tiny fish. You're in this giant city. I'm living in this little village. I have just this circle of about 100 miles that people come and maybe hang out at my place and we do a small project there. I'm not gonna impact your business. Can we agree to, I won't impact your business and I got it on my stationery. I can't go and just.
Well, I understand what you're saying. So you're saying that you were using your name as your business for a long time, and to restate your question, the person who came after you telling you to cease and desist from using your own name was using the same name in a larger market, but they used it, they used it in a contemporary context, not back when you were using it. You were by far and away the first, and you were using it commercially. And you're saying that you contacted them and that you conceded to not using it very much.
Yeah, I just.
This is why you never represent yourself,
Yeah,
because
so
you were totally using it. And are you using it now, or did you stop? Okay, good. All right. So then you did a fine job. All right, never mind. I take that back. All right, well, so that worked. Good. Well, I would have never, ever wanted you to say, I'm not using it that much. I only have people come over to hang out, because it doesn't sound commercial, but it sounds like you did a better job when you're on the phone with him.
Yeah, I just try to be reasonable.
Yeah.
I said, man, I got no money.
Well, you're
to
very,
do that."
very, it's very fortunate that reason works. Sometimes reason doesn't always work, but it's good when it does. Well done. Yes, and then I got to get switched, then I got to switch to contracts, and then we'll come back to questions after the contract review.
So let's just say that I have published works from years past, so it's too late to register for copyright. And let's just say that.
You really love this. You're riding this copyright registration. Go ahead.
Let's just say that somebody more famous and more wealthy is able to steal that and uses it. You're saying that I still have recourse in the
Yeah.
court of law, right?
Yes.
So that being said, wouldn't you say
That's a very attractive to people who want to work on contingency.
So in the court of law, you're saying that maybe with all that said and done, maybe the copyright, the registration isn't really necessary, at least for musical works.
No, it's not. I mean, it is for filing in federal court, but that may be subject to interpretation at some point. That's relatively recent, but you can, I mean, there's a lot of courts, right? You don't have to file in federal court. You still have recourse. I'm not saying don't register your copyrights. I want to be super clear about that. And register your copyrights. For the love of God, everyone in this room, register your copyrights. And if you don't want to, and you can't afford it, just come talk to me outside of this, because I want to be clear, you need to register your copyrights. All right? And I can help you do it. And if you do want to do it, I can help you do it in a way that saves you the most money. Okay, so I'm going to transition. What?
Let me stop this.
Okay.
Respectfully.
Okay.